Continuing this talk about manslaughter and causation, there's two very different stories. If I was trying to prove causation that somebody harmed me or perhaps my child, it would be a very high threshold for me to prove the action, the recklessness was so extreme that it literally caused the death of a member of my family. Crown prosecution or prosecution services in different countries have two criteria. Is it in the public interest? Is it going to be a successful case? Will they win? And they will often say to somebody, no. So you can go to a civil court and try to prove causation in medical negligence, for example, or negligent manslaughter. What's quite different is if I'm trying to prove it or if the state is trying to prove it. As we saw in the Angela Hock, HOCK case in America, the case was pushed by the prosecution for 3 years and failed. And as I've mentioned in other videos, that prosecution don't always even care if they win. They probably do care to win. It's better for them. But just by having the case, they've already put into the public opinion and public psyche that home birth, for example, is dangerous, because this is the main topic we're looking at. So the thresholds are different. If I take a case, it's a very high threshold. If the state take a case, they can take one with a very low threshold. Doesn't matter if they win or lose, they can just take the case. They've got all the money in the world. And as we saw with the case in the UK, Lucy Letby, slightly different, not home birth, but a neonatal nurse accused of murder. Zero evidence, only some circumstantial evidence. That doesn't prove she caused any deaths, and yet she's in jail for 15 life sentences. So if somebody has a case against them, it's very serious, even if there's no evidence that they caused harm to somebody. That's why I'm making these videos, because it's a very important topic for all the birth workers, whether you're a doula or a midwife, deregistered, unregistered. In the Angela Hock case, she was a not licensed midwife, but a very capable, competent midwife with a lot of training, who I think since she's done, had the court case, she's done more training. I don't think, I know. And she's done some of this training with Breach Without Borders, which is fantastic. But that's breach. We can have a death from any event at any birth, because a baby could have trouble during the pregnancy. So really we need to be looking at predicting problems. That's listening to the baby's heartbeat if the mother allows. There's two overriding guidance for hopefully all of our clinical practice: what the mother allows and what the law provides. Together, this is respectful maternity care. What we have is disrespectful maternity care, including obstetric violence, in many hospitals most of the time. Cutting cords without consent, pushing inductions, giving injections, saying, don't worry, this is good for you. And the person lives with the consequence, whether they have a side effect, an unintended consequence from any medical procedure, particularly unnecessary ones, and everything has a risk. There's even a risk with a latex glove causing anaphylactic reaction. I've experienced this with a client of mine in a hospital, and thankfully we were able to help her. A paracetamol could have a negative effect. So we have to think very carefully what we're doing. And quite often the hospitals are in favour of doing too much too soon, because they don't want to be accused of doing too little too late. Therefore, they tend to push things. They're pushing things because they're driven by fear of being told off or wrong. Now, there's a clear case on manslaughter in Commonwealth law. Ademico, who was an anaesthetist, wasn't paying attention. His patient died from lack of oxygen because the period of time that he was not paying attention, looking at perhaps his phone, I think it was, or something else for quite a few minutes, was way beyond reasonableness. It was beyond the professional body of knowledge. So other anaesthetists said, I would not have done that. And that's something useful in every case. So if you watching this are thinking, can I help with any of the cases? Yes, you can. With your own case, you can write a statement of fact and complain to the organisation, and complain outside the organisation. Go to an ombudsman, go to a civil court, go to the police for a criminal prosecution. If you had, for example, assault, battery, trespass to the person, sexual violation, or even suffered a death, perhaps of your baby, you can write a statement of fact that becomes evidence. Other ways and things that people can do to help watching this: can I help another doula or midwife who's being challenged? Yes, you can write two kind of statements: one, a general one, and two, a specific one. Generally, you could say, in your opinion, based on your knowledge and experiences, this is a reasonable or not reasonable thing to have happened. So you're looking at the facts and you're weighing them up, you're testing and verifying what's actually true, and you have a reference for any of the facts, not just an opinion or hearsay, as often is the case with allegations. And specifically, you can say, in this case, I can see that Mrs. Smith, the midwife or doula, acted reasonably. She called an ambulance, she commenced resuscitation. And equally, if that didn't happen, and you're writing an expert witness report perhaps for a family, you can say the person delayed calling an ambulance, they delayed giving resuscitation. You can say and specify what that delay was, how many minutes, and what the clinical picture was. So each situation has a unique individual clinical picture, unique circumstances. So when we look at a guideline, that is not unique. It's a guideline for general things. So we can say why we deviated from a guideline, or why the guideline was not relevant in a particular situation. As always, I'll keep the videos fairly short and invite people to comment, share things, and feel free to ask any questions.